Whether you've already scheduled mediation or are just beginning to explore mediation as an option, this video is for you.
Over the next 5 minutes, we'll break down what mediation is, what you need to do to prepare, and how mediation is helpful regardless of the outcome.
Simply put, mediation is a method of resolving disputes. A neutral and impartial third party, the mediator, facilitates communication between two or more parties to resolve their dispute in a confidential setting. Unlike a court hearing, where the judge makes the final decision, in mediation, the parties involved have control over the outcome. The goal here is for all the parties to agree on an acceptable solution.
Once you have a date and time for mediation, start pulling together all relevant information. This may include contracts, emails, financial statements, custody schedules, school calendars, previous agreements, receipts, court documents, anything that helps support your position. You'll also need to pay any mediation fees in advance of your session. It is best to do this well ahead of time since not all payments can be made online, and your session may be rescheduled if payment has not been received.
Your mediation session will either be held virtually or in person at the courthouse. If it's virtual, it's important to join the session from a private location with reliable internet. You also want to make sure your device is fully charged. If it's in person at the courthouse, it's important to give yourself enough time before your session to park and go through security.
And if you're wondering if you need to hire an attorney, you don't. But if you chose to work with one, be sure to meet with them before the session. They can explain your rights, guide you on how to approach negotiations, and help you set realistic expectations. It's also important to note that if you have limited English proficiency, you will need to arrange for an interpreter as one will not be provided for mediation sessions. Every mediation session can be broken down into 4 different stages: opening statements, joint discussions, negotiations, and agreement.
Every mediation starts with opening statements. Your mediator will introduce themselves, explain the rules, and outline the process. Each party is then given the opportunity to give a brief opening statement summarizing their position. This stage sets the tone for the entire session, so it's important to be respectful and open to constructive conversation.
After opening statements, joint discussions begin. This is the stage where the parties start to work through the issues together. The mediator will guide the conversation, keeping it structured and ensuring that all parties have an opportunity to speak. During this stage, the mediator may also meet with each party separately. These private sessions are confidential unless you give the mediator permission to share what you've discussed. It's important to remember that the mediator is an impartial and neutral third party, and as such cannot give legal advice.
Once all parties have shared their positions and interests, negotiations begin. Again, the mediator is here to keep the conversation structured and to also help the parties explore solutions. The negotiation stage is the longest stage in a mediation session. The conversation continues to go back and forth. Offers and counteroffers are explored until an agreement is made, which brings us to stage 4.
An agreement is reached when all parties involved settle on a solution. If you come to an agreement that resolves your dispute, the mediator will draft a settlement agreement that all parties will have an opportunity to read and then sign. The settlement agreement is a legally binding document, so it's important that you fully understand the terms before signing.
If mediation ends without reaching an agreement, your session still has value. The conversation between the parties provides insight into the issue and can potentially help narrow down the issue. And if your case does go to court, you will be more prepared after going through mediation.
That sums up the mediation process. If you have any questions, please call or email our mediation staff. They are here to help and get you on the road to a resolution. For mediation services in Orange County, call 407-836-2004 or email orangecountydrs@ocnjcc.org. For services in Osceola County, call 407-742-2451 or email osceolamediation@ocnjcc.org.